Good morning, everyone. I'm Mike Longyear, and I'd like to welcome you to the Read Longyear, Malnati, Corwin, and Burnett November webinar. These webinars are produced within our firm, and I want to thank Attorney Meng for organizing and coordinating all the background for this webinar. Today's topics are really sort of about common issues that we find in working with clients on estate planning, both for individuals and families, both on the multi-generation planning, common issues that appear, and then also those types of issues that come up in second marriages. Also, we'll be touching on committed intimate relationships. For those of you familiar with Washington community property law, you know that becomes an important issue. And because we are on a pretty tight schedule, I'm going to be watching the clock and making sure that we stay on the agenda. There will be opportunity for questions and answers later at the end of the program through the Zoom Q&A function. And please take the time, if you have a question, to enter it. And of course, we are available after the program to answer any questions or discuss any particular situations that individuals or their families may be facing or considering as part of their planning. And then also, for those of you that have not seen our webinars before, they are on our website, rlmcblaw.com, and as well as various blog posts by some of our presenters today and other attorneys at the firm. So again, I want to thank you and welcome to the November webinar. And I'm going to actually probably just remind everyone about the Q&A function, and then again ask that you consider these planning issues for both individuals and families. And I'm going to get started with our first presenter, Carla Calogero. Carla has been with the firm for almost 10 years. She comes with not only her law degree, but also a master's in bioethics, and is a go-to person and resource for considering complex planning issues around that. And today's topic, though, that Carla will be presenting on is on planning considerations for young beneficiaries. So Carla, I'll let you get started.
Thank you, Mike, and welcome to all. I'm looking forward to today's program. I'll get us started with some discussion about estate planning considerations with young beneficiaries. We'll talk about some of the pitfalls that we see and some options when considering gifting for young beneficiaries. And like Mike said, we'll do Q&A at the end of all of the presentations. So first of all, who are young beneficiaries? Well, we certainly know that minors are young beneficiaries, and the age of minority in all but a few states in the country is under age 18. And the issue is that a minor cannot inherit property in their own name, which means that an adult or perhaps a professional fiduciary must hold and manage the property for the benefit of a minor until age 18. But young beneficiaries in our planning includes a larger class than just those under age 18. We think about young adults and planning for them and gifts to young adults. Then we ask the question, well, what is a young adult? And it depends a bit on the options that you're utilizing, but a young adult could be considered someone up to age 21, perhaps age 25, or even age 30 or 35, if we're talking about some trust for young beneficiaries. We are in the business of laying out for you worst case scenarios. So we'll talk first about what we, from our planning perspective, may consider some of those worst case scenarios to avoid. So issue that a minor beneficiary is named as a direct beneficiary. So as a direct beneficiary, this means they are named under your will. Perhaps they're named as a payable on death beneficiary for a life insurance policy. But a minor beneficiary may also receive as a contingent beneficiary class. So, for example, I give to my cousin Betty $100,000 or to her descendants if she predeceases me. Well, if Betty has predeceased you and she has descendants, and any of those are minors or young beneficiaries, there needs to be a contingent plan for those individuals. So if this occurs and there's no planning or protections in place through the options that we'll talk about, the court will become involved. Court intervention will be required. A probate guardian ad litem will be appointed to put plans and protections in place that you did not. One of the options here with a court-appointed guardian ad litem is a court-established trust, which will be court-supervised until at least age 18, or a conservatorship proceeding, guardian of the estate conservatorship will be established and court-supervised until age 18. Or if the funds are somewhat modest, perhaps the court will just order that those funds will be held in a blocked financial account until age 18 with no access or use absent another court order. Another worst case scenario is trickle down gifting. So what I mean by trickle down gifting is that we assume that if I give to my daughter, Jane, that my grandchildren, Jane's children, will receive benefit from that gift to Jane. But that doesn't always occur. That is, the gifting doesn't always trickle down. And there are a number of reasons why it may not. I'll go through those briefly. So first, the beneficiary parent's estate plan is inconsistent with your trickle-down gifting intent. Perhaps they leave everything to a spouse. If they're married, there could be commingling of community and separate property between the beneficiary parent and spouse. And then what if a divorce occurs? Or what if the beneficiary parent dies before the other parent and the other parent's estate plan governs? And of course, remarriage can be an issue as well. Other issues while trickle down might not succeed, unknown circumstances. For example, creditors of the beneficiary parent or spouse, incapacity of the beneficiary parent or spouse, or of course, just waste or spend down by the beneficiary parent or spouse. So presumptive generational trickle-down gifting is not a good option. I'll discuss three options when you're planning for protections for young beneficiaries. The first option that we utilize commonly are trusts for young beneficiaries. Another option are what are called custodial accounts. And finally, 529 education accounts. So like all types of trust, a trust for a young beneficiary could either be lifetime or testamentary. If lifetime, you are establishing and funding the trust upon your life. It could be a trust for direct benefit of the beneficiaries, or they could be beneficiaries under your trust when you pass away. So if it is a revocable trust, that is a lifetime or revocable living trust, you retain control and ownership of the trust assets as long as you are alive and have capacity. If it is a lifetime irrevocable trust, you hand over control to a trustee and you make an irrevocable gift to the trust. Generally, this is undesirable except for tax planning purposes. And then most commonly, there is a provision in your will or your living trust to establish a young beneficiary trust upon your death. This is testamentary. So there are some very good things about pre-planning and establishing these trusts for beneficiaries, either during your lifetime or under your testamentary documents, because you decide. You decide the trust purpose or purposes. You decide who will be trustee and who will be successor trustee if they can't act. You decide the duration of the trust. Will it be in place until age 25, 30, 35? You decide the distribution standards and the structure for distributions. You decide what accounting and notice requirements you want to have in the trust. And of course, you get to decide who the remainder beneficiaries are of that young beneficiaries trust. So like I just described in the preceding slide, trusts for young beneficiaries enable you to have more control over the gift and over the distributions of the gifts during the beneficiary's lifetime. Generally, trusts are advisable for substantial gifts or inheritances. And I know you'll ask, what is substantial? Well, it is subjective, so discuss that with your attorney. And generally, they afford greater accountability and fulfillment of fiduciary duties with a trustee in place. Custodial accounts are a unique type of financial accounts, and they're often referred to as UTMA accounts, which stands for the Washington Uniform Transfer to Minors Act. Even though minor is in the title, these accounts can be maintained up to age 25, you decide. They are taxable investment accounts. The assets are considered to be owned by the young beneficiary, although the accounts are fully managed by a custodian who is not the beneficiary. A consideration for custodial accounts is that because they are considered owned by the beneficiary, they may impact financial aid. And like trust, you can establish custodial accounts during your lifetime or within your testamentary documents. If during your lifetime, it is considered, that is a contribution to the account, is considered an irrevocable gift, which means it won't be in your estate when you pass away. There are no contribution limits to custodial accounts, and they remain in place after your death. You just need to designate a successor to be custodian for the account. And if you're establishing custodial accounts under your will, you just need to identify that that's the mechanism and identify a custodian for the accounts for young beneficiaries. 529 accounts are another planning option to make gifts to young beneficiaries, and these are state-sponsored plans that offer tax-deferred growth. 529 accounts would be established by you during your lifetime, and that means you always want to name an account owner survivor in case you pass away during the lifetime of the account. 529 accounts have an owner, that would be you if you establish it, or the successor if you pass away, and a beneficiary. And as I said, the account owner controls the account. There are tax advantages to 529 accounts in that the earnings grow free from income taxation. There are some restrictions on 529 accounts in that the disbursements from the accounts can only be for qualified educational expenses But that is a large umbrella. That can be tuition, can be room and board. Really, the umbrella is quite large. If you make a distribution or take a distribution from the 529 account for non-educational purposes, there will be a 10% tax penalty. And getting back to another tax advantage of 529 accounts, they are considered a completed gift. That is, the contributions you make are, which means the accounts are not included in your estate at your death, but does use a part of your gift tax exemption at the federal level, if that may apply to you. Washington 529 accounts have a contribution limit of 500,000, and unlike custodial accounts, 529 accounts have less of an impact on financial aid. The impact should be no more than 5.6% to the financial aid package. In Washington, we have two types of 529 accounts. I'm sure you've heard of them. There's the Dream Ahead and the Gets accounts. So the Dream Ahead account is the 529 savings account. It's an investment account. And so contributions hopefully grow over the lifetime of the account, but are subject to fluctuations in investment accounts, and also have no inflation protections. Excuse me. The Get account, on the other hand, is a prepaid plan. You purchase guaranteed tuition units at a fixed price today, which means if you purchase the equivalent of 5 credits at a university today, you will get 5 credits paid from the Get account, even if 5 credits today is a tenth of what 5 credits might be in 10 years in terms of the purchase price. And for 529 accounts, the owner does retain control over the types and the timing of distributions from the accounts. So just a few parting do nots. In general, do not assume that your current young beneficiaries will not be young when you die. Do not assume that a young beneficiary will benefit from a gift to their parents. Do not name minor or young beneficiaries to receive directly under your will or trust or life insurance policy, for example. Do not name minors or young beneficiaries as transfer on death beneficiaries on retirement accounts, life insurance policies, etc. But do name a trust on that beneficiary designation, a trust for young beneficiary under your will or that you have established during your lifetime. You may consider irrevocable life insurance trust if federal tax planning is a dominant priority for you. Or you may name a custodian as to receive a young beneficiary's transfer on death benefit. But again, remember, the custodial account may only be in place up to age 25, and you have no control over what types of distributions the custodian makes. In parting thoughts, review your retirement account and life insurance policy beneficiary designations regularly, including now, and seek the advice of your estate planning attorney and your financial advisor, because, of course, none of the information in this presentation is legal or financial advice specific to your unique circumstances. Thank you.
Thank you, Carla. That was really helpful and excellent overview of these important issues and some of the common issues that we find when folks haven't had the opportunity to think through planning for young beneficiaries and heirs. So very helpful, and certainly appreciate your pointing out that people need to check with both their attorney and their financial advisor so that those documents are consistent and not at odds with each other. And again, Carla will be available for questions on the Q&A at the end of the webinar. Our next presenter is Anton Cauthorn. Anton is an attorney practicing both on estate planning, probate trust administration, and comes with a master's in tax from the University of Washington, and now teaches at the Seattle University School of Law in their estate planning as well as their estate and gift tax area. But today he's going to be talking about a very particular topic, and that is powers of attorney for young adults. And I'll let Anton go forward. So Anton?
All right. Thank you, Mike. Give me 1 second to get my slides up here. Okay. As Mike said, today I'm going to be talking about powers of attorney for minor children, young adults, and aging parents. And this topic is really diverting from what we typically think of in estate planning, where we plan for ourselves. We're making sure we have all of our documents in place, so we're taken care of, our wishes are carried out. And this topic is looking at those other people in our lives that we may be providing care for and making sure they have the proper documentation so they're cared for if something happens to us. So let's get into the basics of this and talk about why we should think about this and what we should do to make sure we protected those people around us that we may be providing care for. So first, one of the basics, many of you may be familiar with this, which is what is a power of attorney? Because that's what we're going to be talking about today, looking at powers of attorney and using them in interesting and unique ways to provide for others around us that we may be providing care for. And so in its simplest form, a power of attorney is just a legal document where we are allowed to name somebody else to act on our behalf when we cannot. As we'll find out, we can actually use these in unique ways to name people to act on other people's behalf, being minor children too, and thinking about when we should have somebody else draft one of these, naming us to act as their agent on their behalf. And first question we always have with the power of attorney is, why do we need a power of attorney? And the reason we need powers of attorney is to make sure if something happens to us, if we're incapacitated from injury or accident, if we get dementia as we age, we can't manage our own finances and medical decisions, we want to have the ability to name someone to look after us and make those decisions for us. So someone to pay our bills, someone who can make medical decisions for us when we can no longer do so. That's why we draft powers of attorney. And traditionally, we have two different types of powers of attorney. A financial power of attorney, where we name somebody else to manage our finances, paying bills, looking at our investments and making sure they're invested properly. Also, we do a healthcare power of attorney, naming somebody to make medical decisions, such as choosing where you're going to stay in a nursing facility, different options for medications, different options for treatments. So we're naming somebody to do that through a healthcare power of attorney. And these are the traditional powers of attorney that we will draft. Now, what I want to look at is moving away from the traditional powers of attorney and looking at two major topics first, and then looking at a third one, possibly if we have time here. And the first one is the issue of if we have minor children. So if you have minor children under the age of 18, they can't draft a power of attorney. One of the legal requirements to have a power of attorney is you must be at least 18 years of age. And so the question is, well, do they need one? And if so, how can we create one or create this opportunity to care for them if the parents are unable to do so? Second one is for young adults. So somebody over 18, can they draft a power of attorney? And the question is, when should they do that? So let's look at these two topics here. So with the first topic, one thing I want to look at is these different common scenarios we see with people who have minor children. So maybe you're somebody who has minor children and you have to go to work every day and you have parents who are taking care of your children while you're away. So you go off to work, parents are taking care of your children. And so there's a concern, what happens if something happens to your child? Another situation, maybe you're a grandparent and you're taking care of your grandchild while your children are at work. So you're helping take care of those children. So the question you may have is, well, what happens if you need to provide care for that child? Another situation, maybe you have a nanny or an au pair, somebody who's taking care of the children while you're at work, who's not a family member, who's helping take care of those children. And then the final scenario I'm looking at here is maybe you have a second marriage, or maybe you're in a partnership and you're providing care for each other's children, but you're not the actual legal guardian of that child. And so in all of these circumstances, you have somebody who is not a legal guardian, who's taking care of a child, maybe daily on a daily basis, or maybe every other day or some other time period, but somebody who's consistently providing care for a minor child who is not the legal guardian. And the issue that comes up in these cases is, what happens if there's some sort of medical emergency? So let's imagine, again, you're the parent, you're at work, and your parents, being the child's grandparents, are taking care of the child, and we have a medical emergency. Maybe we have somebody who's allergic to bees, and we have a bee sting, and that child ends up in the hospital. you're in a meeting, grandparent of the child can't get a hold of you and they have to take the child to the hospital. Does that grandparent have authority to make decisions for that minor child? And the answer is maybe. So technically under Washington law, closest family members will have the authority to make medical decisions on behalf of children, but not every hospital is going to do that. Sometimes they may have fear that they're giving the authority to the wrong person. They may not be quick to give that authority to the person and the caretaker who takes that child in. And so we do have a solution we can do to make sure whoever is providing care for your child, be it a nanny, be it the grandparents of the child, be it your partner who's not the parent of the child, we can grant them the authority to make medical decisions for children using a power of attorney that you draft for yourself. So you can draft your own power of attorney, granting the authority for this other person to make medical decisions for that minor child to take care of them if you're not available. And so this is a very useful tool for those situations where someone else is, again, providing daily, maybe every other day care while you're going to work or you're doing other types of life. Now, of course, this doesn't take away your authority to make decisions if you're available. It simply says, if you're not available, here is somebody you're naming to make those medical decisions for that minor child. Now, there's two different ways we can do this. One of them is we can place this language in your current power of attorney, but the better option is you can draft a separate power of attorney that only does this. It just names somebody else to have that temporary authority to make medical decisions for a minor child when you're not available. And that way that person can just hold on to that one single document. They have it in hand. If something happens, hopefully they never need it, but if something does, they can use that document. Now, another situation that goes hand in hand with this is, well, what happens if you have some sort of significant injury, accident, and you're not able to make sure your child's provided for? Within a document like this, we can also make sure that there's authority for somebody else to provide financial support for your children if you're in more of a long-term care situation where you aren't available to provide the financial support for a child. Now, another scenario where we may want to think about doing one of these temporary powers of attorney is, imagine this. You're going traveling, and maybe it's not a minor child who's young, maybe it's somebody who's in their teens, but you're having somebody else provide care for that child while you're on vacation traveling somewhere. Again, maybe it's a grandparent, maybe it's a friend, somebody else is providing that care. Well, what happens if you're on vacation, you're out of reception, and your child has a broken bone? They need stitches, or they have some sort of other serious injury where they're going to need medical care. Once again, we want to make sure we provide it for who's going to have the authority to make medical decisions and go into the hospital to avoid any issues with the hospital rejecting that authority of the person who's taking care of the child. And so this is a situation where we can solve this using what's called a temporary power of attorney. So when you're traveling, you don't have to grant a power of attorney that's going to last forever. You can draft a power of attorney that says, while I'm on vacation and until I return on this date, this person has the legal authority to make medical decisions for my minor child. And therefore, it's a time-limited power of attorney that could help resolve that issue while you're traveling, making sure that a child will have somebody to take care of them and look after them. And just, I have a personal experience with this. When I was a teenager, my grandparents, a young teenager, my grandparents were taking care of me while my parents were on vacation. And I made the stupid mistake of chipping a tooth, had to go in and get dentist work. And in that case, my parents had luckily drafted a power of attorney that did allow that to be done, taken care of by my grandparents. Now, next situation I want to jump into here is, how do we care for young adults? So this is somebody who's over the age of 18, no longer a minor, and now you no longer as their parent have the authority to make any decisions on their behalf. They're an adult, they can make their own decisions. And so what can happen though is, if you have a young adult, oftentimes you're still helping out with life. Maybe you're providing support, financial support to go to college. Maybe they're on your medical insurance, or maybe you're helping them with their first job. Well, what happens if they end up in a medical emergency? They're in a car accident, they're in a sports accident, and you go to the hospital to try to assist. Will the hospital let you assist? Now, in some cases, the hospital will let you assist. Technically, under Washington law, the hospital should give an informed consent permission to the closest family members who do show up, but they don't always do this. Actually, I have a situation again in my family where I've dealt with this. My brother used to ride motorcycles. And when he was 19 years old, he got in a motorcycle accident, was in the ICU at Harborview, unable to make any of his own decisions. So the whole family was there, my father, my mother, and myself, and we were trying to make medical decisions. And the doctors wanted to remove a portion of his liver, and we were asking them to wait to see if they really needed to do so. And the doctors didn't want to listen to our advice because they wanted to do this. Now, the only reason the doctors did not remove a portion of his liver was because a senior doctor came on shift and said, we think he's going to be okay without doing the surgery. They didn't do the surgery, he was fine, but they wouldn't listen to us. So the lesson from this is, if you have a child who's over the age of 18, encourage them to draft their own powers of attorney, naming someone else to act on their behalf, likely you as the parent, so that you can provide care for them if they do end up in the hospital. This is also, what if they end up in the hospital? Can you pay their bills? Can you make sure everything's being taken care of financially for them as well? So it's very important when somebody reaches that age of 18, get them to draft their first estate plan, in the sense of have them draft powers of attorney, naming you as their healthcare and financial power of attorney to make decisions for them. And I will go ahead and end here so we can move on to our next presenter.
Anton, thank you. I think 1.2 on those family members is if the parents are divorced and there's no power of attorney, who has that decision for that young adult to make decisions? And I think, unfortunately, we see that come up as an issue a little too frequently. So those simple documents are super important. So thank you. Our next speaker is Josh Reinertson, and Josh has been an attorney with the firm for going on 6-7 years now, Josh, and also has a master's in tax degree from University of Washington, as well as his JD from Seattle University. Josh works in estate planning as well as probate trust administration, and he'll be talking with us today about planning in second marriages and sort of related topics. So Josh, you want to get started?
Yeah, thanks for the introduction there, Mike. Yeah, as Mike mentioned, I'll talk to you a little bit today about some of the concerns, issues, considerations, and tools that we think about and use in estate planning for, second, third, fourth, fifth marriages. Really what we're talking about is planning for blended families with stepchildren, but some of the concepts can also apply to unblended families and also to unmarried couples. And I apologize in advance, I'm going to talk pretty fast here. There's a lot of information to cover, and this is going to be a pretty high-level overview, but hopefully there's some ideas for you to think about. All right, so jumping straight in. So what are we talking about with estate planning for subsequent marriages? Really, there are a number of possible issues to be addressed, but I've broken them down into 3 major areas. First is protecting assets in the event of divorce. This is really ideally addressed through a prenuptial agreement entered into by spouses before the marriage occurs, but can alternatively be entered into after the marriage in what's called a postnuptial agreement. And I'll touch a little bit more on this in a few minutes. The second and third points are about protecting children from disinheritance, both intentional and unintentional disinheritance. In unintentional disinheritance can just simply occur from overspending and depletion of the estate after the death of the first spouse. So, for example, take a couple where one spouse has a child from a prior relationship. That couple has wills that leave everything to the survivor, and the survivor's will leaves everything to the child. But what if the surviving spouse develops dementia or some other disability that requires expensive long-term care that can rapidly deplete the estate and not leave anything for the child? And maybe that's a completely appropriate strategy. If the child's older, has their own assets, maybe leaving everything to the survivor makes absolute sense. But if the child's younger, maybe it would be more appropriate to have some sort of carve out in the estate plan to ensure that they receive something for their future, and then the surviving spouse can rely on other assets that might be available to them, such as state aid or some other resource. Or what if the surviving spouse just gets remarried and then gets entangled in a nasty divorce from a later spouse? All of those assets that the second spouse inherited from the first spouse, that can be up for grabs in a subsequent divorce. And in intentional disinheritance is just a spouse writing a child out of their own will. So the risk might be obvious at the outset of the marriage if the child and the step parent don't get along, or it might develop later after the death of the natural parent. Or what if the surviving spouse marries into a family and develops a closer relationship with that family, or has additional children of their own? That all can lead to a full or partial disinheritance without some advanced planning. So here's a few of the kind of factors and considerations we think about, and this is just, a smattering, and there's many more. But first, what are the sizes of each spouse's estate? The spouse coming into a marriage with a larger estate might have a stronger interest, not in preventing the survivor from having the use of assets for their lifetime, but just having a more secure and certain vehicle to manage and preserve those assets for the future generation. And what are the relative ages of the spouses? A younger spouse might be more likely to remarry or have additional children. Is the other spouse foregoing resources by getting married? Maybe they're foregoing job opportunities or having giving up government benefits. Who should be managing your financial affairs while you're alive but incapacitated? If you have a complex financial complex financial business interests, maybe someone other than the surviving spouse would be more appropriate person to manage those assets through a power of attorney document like Anton was talking about. Who should be managing your estate after your death? A lot of people appoint their spouses as the executor of the estate, but does it make sense to have the spouse in that role? Could you appoint a third-party trustee to act as a completely independent executor, or as a co-executor with a spouse and help avoid conflict with stepchildren? And what about your children and stepchildren? Are you going to treat them equally? Or is it fair to treat them unequally? What are their ages and needs? Does one child or stepchild have special needs that require more resources for care going into the future? And if you leave a bequest to your child in a trust, should the step-parent be responsible for managing that inheritance? Or would it be more appropriate to have a third party, like a professional trustee? There's no real right or wrong answers to any of these considerations, and there's no uniform approach, but those are some potential, issues that might be appropriate to consider. Okay, so I just want to touch briefly on community property since it underlays a lot of issues with estate planning between married couples. Washington is a community property state, and that means that spouses have a 1/2 undivided interest in property acquired during the marriage. So for example, any income the spouses generate from their labor, that's all owned 50-50 by the spouses. The major exceptions to community property is that assets that are acquired before the marriage and brought into the marriage, that's all separate property of the spouse that brought it into the marriage. Assets received as a gift or inheritance by one spouse during the marriage, that's considered separate property. And then any assets that the spouses agree in a written agreement are separate or community, that will control. And one important note here is community property interests can arise between unmarried couples as well. There's a judicially established doctrine called the committed intimate relationship doctrine, which basically says that a court can determine if a couple's been living together long enough in kind of a marriage-like relationship, the court can deem certain assets community property of the spouses and not their separate property. And the court looks at how long the couple's been cohabitating, how they hold themselves out. Do they hold themselves out as married? Is their relationship exclusive? And there's a number of other factors as well. But I just raised that to make you aware that just because you're unmarried doesn't necessarily mean you're going to escape the community property framework. Okay, so why does community property matter? First, you can only dispose of what you have an ownership interest in. If it doesn't matter if an account is in your name alone or if it's in both of your names. If it's funded with community property, you can only dispose of half of that account under your will. Second, if you don't have a will in place, all of your community property under Washington law, that all goes to the surviving spouse by default, plus 50% of any separate property. So you can unintentionally disinherit one of your children if you don't have appropriate provisions in place in your estate plan. Third is exposure to creditors. The laws are pretty complex here and vary depending on the particular situation, but generally there's a pretty strong presumption in favor of community liability. So creditors of one spouse can often reach community assets although separate assets are generally not going to be available to satisfy separate debts of another spouse. Fourth, there's limitations on what one spouse can do with community property. For example, one spouse can't encumber unilaterally the community property with debt. You need the consent of both spouses. And then likewise with gifting of community property, you need the consent of both spouses. And then finally and importantly, most courts treat community and separate property differently at divorce. Courts have broad discretion and they have the authority to make what's called a just and equitable division of property at divorce. And that means they can potentially take the separate property of one spouse and give it to another spouse. That's, typically courts avoid doing that. So to the extent that you can define what is community and separate, those separate assets will have a better chance of staying with the spouse that brought them into the marriage. And depending on what your goals and needs are, a lot of these issues regarding community property can be addressed in a prenuptial agreement or a postnuptial agreement. You can define what is going to be community property and separate property, how much each spouse is going to contribute towards home and living expenses. You can define how assets are going to be divided in the event there is a divorce. And then you can also address, is one spouse going to pay maintenance and support to the other spouse after the divorce? That can all be addressed rather in advance rather than just leaving it up to the court. Okay, so now I'm going to talk to you a little bit about strategies that are pretty common to avoid disinheritance of children. The first strategy is making lifetime gifts to your children while they're alive. There's no gift tax in Washington, and Carla touched on this earlier. You can give up to $17,000 a year without filing a federal gift tax return. A lifetime gift assures that a child's going to receive something from your estate. If your estate is large enough that you're worried about having a Washington or federal estate tax liability at your death, lifetime gifting can be a really effective tool to reduce the size of your estate and also provide for your children in advance. A major downside of lifetime gifting is that you lose use of those assets. If you end up needing those funds for medical care or for some other reason, you won't have access to the gifted funds. Another downside is that if you gift an appreciated asset like stock or real estate, your child receives those assets subject to any appreciation in value on that asset since you acquired it. So if you receive an appreciated asset, if your child receives an appreciated asset from you, they turn around and sell it to generate cash. They might have a hefty capital gain tax bill to pay when that asset is sold. In contrast to that, if an asset is transferred at death, for example, under a will, that beneficiary is typically only going to pay capital gain tax on the appreciation from the date of death forward. So that's an important consideration when talking about lifetime gifting. Another option is simply just making what are called first death distributions under your will. And this is just a way of saying that your will has a carve out for your children when you die. It could be a specific piece of property, specific amount of cash, or it could be a percentage of the overall value of your estate, and you leave the balance to the spouse. This has the advantage of allowing you to retain use of the assets during your life if you need them, if unexpected, healthcare expenses come up, or if the relationship with your child, changes and you do want to, reduce the amount of your estate going to them. This allows you a lot more flexibility than making lifetime gifts. And then, like I just mentioned, the benefit here is that because the asset was transferred at death, that child is only going to pay capital gain taxes on any appreciation from the date of death forward. A third option here is what we call mutual wills. A lot of married couples that do estate planning together end up executing what are called reciprocal wills. And that just means that the wills mirror each other in their terms. So kind of, everything to the surviving spouse, everything to the children at the survivor's death. Pretty standard. Both wills would say that. A mutual will, on the other hand, is an enforceable contract between the spouses where they agree they will keep certain provisions in the will in place, and that's usually the dispositive provisions for the children. The contract really becomes effective at the first spouse's death. Prior to that, either spouse can revoke and change their will, but once the contract becomes effective at the first death, the survivor can't make changes to the will. If they do make changes to the will, then the beneficiaries under the will that would have received under the mutual will had it not been changed have a enforceable right that they can bring in court to receive those funds. And I'm going to wrap this up here. I'm running out of time, I believe. So finally, what I want to talk about is marital and family trusts. These are trust provisions that are in your will, and they appoint someone called a trustee to manage assets according to the terms that you write into your will. So, for example, you can leave all or a portion of your estate in trust for your spouse. The trustee could be your spouse, or it could be a third-party trustee, or you can appoint a third-party trustee with your spouse as co-trustee. So there's kind of a balance of power and oversight, making sure that trust is followed. But the trustee is bound to distribute assets in the trust according to the trust terms. Common provisions in the trust would be for the trustee to use trust funds during the surviving spouse's life for their healthcare needs, educational needs, and kind of general support and welfare, so that they can maintain their accustomed standard of living. And that's a limitation, so they're not overspending the inheritance. And the trust could also provide that if the survivor remarries, maybe they only have access to the income then, and that preserves the principal amount in the trust for the children when the survivor dies. So I think with that, I'll end it here. I'm way over, so I'll turn it back to you. Thanks, Mike.
Great. Thank you, Josh. That was excellent, very informative, and certainly touched on many of the issues that we see with clients working through on second marriages or committed intimate relationships, as well as what we'll call a traditional marriage. Our next speaker is Meng Yu Che. Meng is also a graduate of Seattle University Law School and has an LLM from the University of Washington. He came into law with a background in tech and is, in my mind, super organized and efficient with technology, which I super appreciate. So Meng is going to be talking about transfer on death deeds, which is a interesting law that was adopted in Washington over a decade ago, and kind of lead us through some of the issues and opportunities for planning with transfer on death deeds. So Meng.
Thank you very much for the introduction, Mike. And can you just please confirm that you can hear me as well as see my slides?
Yes.
Excellent. Thank you very much. Good morning, everyone, and thank you for joining the Read Longyear November webinar. As Mike mentioned, my name is Meng Yu Chi, and I will be speaking on the topic of transfer on death deeds. With my legal practice focused on estate planning and probate, I continue to look for ideas and suggestions to share with current and potential clients to help people proactively plan for their future. One area that comes up often with many people I speak with is regarding non-probate transfers of property to avoid probate. Now, while Washington probates are economical and have garnered undeserved negative feelings based on horror stories from other jurisdictions, such as California, there are situations where non-probate transfers make a lot of sense, such as with modest estates or someone not wanting to modify an existing estate plan to transfer a real property interest that they received or they obtained after creating their estate plan. Thus, today I want to share with you all some general information on what a transfer on death deed is, the benefits to using a transfer on death deed, some important considerations when deciding to use a transfer on death deed, and some best case scenarios when a transfer on death deed would likely be a good option. So first, what is a transfer on death deed? And the Washington legislature passed a bill authorizing transfer on death deeds in 2014, so we are almost at 10 years. They codified it under the Revised Code of Washington, Chapter 64.80, and is known as the Washington Uniform Real Property Transfer on Death Act. That's a lot. However, under the statute, what a transfer on death deed is very simple. A transfer on death deed is a real property deed that contains the essential elements and formalities of a recordable Washington deed that states the property transferred to the designated beneficiary occurs at the transferor's death and is recorded during the transferor's lifetime in the public records of the county where the real property is located. Now, some key benefits to using a transfer on death deed are where the transferor wants to convey real property to a designated beneficiary or beneficiaries outside of a will as a non-probate transfer. Thus, a transfer on death deed can help modest estates potentially avoid probate altogether, especially if other assets have similar beneficiary transfer mechanisms, as Attorney Carla Calogero touched upon earlier in regards to beneficiary designations. Second, a transfer on death deed can be revoked during the transferor's lifetime if the transferor changes their mind for whatever reason. So let's say the transferor decides they want to actually sell the property to fund their retirement or fund their medical care. They can totally do that. If they decide that they want to change the beneficiary, it's going to be expensive because each time you record a deed, it's $204.50 right now. And after January 1st, 2024, that price will increase by $100 to $303.50 in King County as of January 1st. I checked yesterday. So they can totally be revoked. They can totally be modified. Nothing's set in stone during the transferor's lifetime. Now, additionally, during the transferor's life, a recorded transfer on death deed does not affect the transferor's current ownership or create a legal or equitable interest in the designated beneficiaries. This is very important, again, because the transferor can change their mind. If they want to, they can go get a mortgage on the property. They can sit there and do anything else with the property because they own it during their lifetime. It's theirs, assuming there are no other property interests involved. The transferor can basically encumber, sell the property if they want to, everything. Now, for the designated beneficiary, their interest is what I like to communicate as it's just waiting there. It's waiting for the transferor's death. So their interest has not vested until the transferor dies, in which case then the beneficiary, that means the beneficiary's ownership, they can't do anything with it because they don't own the property until the transferor's death. And that also has the added benefit that the beneficiary's creditors during the transferor's lifetime cannot attach to the property as well. Next, alternate designated beneficiaries can be listed. So as I touched upon earlier, you can potentially name additional beneficiaries. So if you have a primary designated beneficiary, if they pass away under the statute, their interest lapses. So if the transferor would like to nominate alternate beneficiaries, they totally can. It's actually recommended if that's what they want to do with their estate plan. And all the way down to potentially tertiary, secondary alternates as well. And this definitely provides more granular control to the transferor over who receives their property interest in case their primary beneficiary predeceases them. Finally, the transfer allows a step up or step down in cost basis in the transferred property at the transferor's death. And I won't belabor that point, as Attorney Joshua Reinertson, did a great job explaining kind of the step up in basis of the property and the minimization potential of capital gain there. Now that we know what a transfer on death deed is and some of the reasons a person may want to use one, here's some considerations people should take into account before using a transfer on death deed. Number one, designated beneficiaries receive their property interest subject to, and I'll let you read the different items there. Suffice to say, the subject to means that the designated beneficiary gets the property interest subject to any person who has an interest in the claim against the property, the transferor's property. So that means, especially under Washington law, where after a person's death, creditors have up to 2 years to file a claim against a decedent's estate to recover. So that means then that the designated beneficiary, if they were trying to get a mortgage or sell the property and get title insurance on the property, they're going to have a bit of a struggle there, because of that 2 years where the creditor could pop up and file a claim against the property. The mortgage and title company, many mortgage and title companies, don't want to take on that added risk during that 2-year period of either issuing a mortgage or insuring title, especially if there could be some potential creditor interest out there that would make their interest junior too. And so you're going to see that some number of different companies just do not opt to either issue a mortgage or are willing to insure title on the property during those 2 years. Last, there is that if there is an existing mortgage on the property and there is a due on sale clause in the mortgage agreement, then that due on sale clause may be triggered at the transferor's death and the subsequent transfer to the designated beneficiary. This is really important because the due on sale clause may sit there and require repayment in full of the remaining mortgage amount if there is an existing mortgage on the property. And so that could create a significant issue for the designated beneficiary if they do not have enough assets to pay off any existing mortgage there and potentially lead to the property going into foreclosure. Next, a transfer on death deed transfers without covenant or warranty of title, even if the deed states otherwise. So think about, this is very similar to a quitclaim deed where you own the grantor in a quitclaim deed only transfers whatever interest they have in the property. It's the same thing with a transfer on death deed, where during the transfer process, whatever interest the transferor had in the property, that's what gets sent over. So this is a consideration, especially if the transferor does not have clear title on the property, because you're basically going to be pushing that interest down to the designated beneficiary. So this may be something that you would like to, the transferor would like to clear up before filing the transfer on death deed. Next, there are several practical requirements to perfect title for a recorded transfer on death deed. So after the transferor dies, the designated beneficiary actually has to take a couple of different steps. Most notably is actually recording a certified certificate of death with the recorder's office in the county where the transfer on death deed is located. This evidences in the public record that the transfer on death deed now is in effect, does transfer to the designated beneficiary because you have the certified certificate of death showing that the grantor has passed away. And this would also typically require filing a real estate excise tax affidavit. The good thing here, though, is if there is no consideration for the transfer on death deed, usually there is not going to be any real estate excise tax due on the when the affidavit is filed. And then next, we have the for a step up or step down in basis. Usually, it's recommended that there be a certified appraisal that is done as close to the transferor's date of death, and making sure that the appraiser knows that the appraisal should be done as of the date of death, so that the designated beneficiary has locked in the amount of the actual fair market value of the property at the date of death. And then last, while no notice, delivery, or acceptance by a designated beneficiary or consideration is required, i.e. transfer on death deed can actually be done in secret almost by the transferor, a recorded TODD is in the public record and can be discovered by anyone searching the public record. So this should not be a significant concern, especially with the after death steps that were listed previously. It's kind of in the best interest of the transferor to make sure to notify any beneficiaries that they are the designated beneficiary and transfer on death deed. All right, so now that we have covered some of the benefits and things to consider when implementing a transfer on death deed, here are several best case scenarios when a transfer on death deed may be useful. First, if the beneficiaries will likely hold the property for several years and not sell. So this kind of deals with the fact that some mortgage companies and title companies will not sit there and insure or provide a mortgage within the first 2 years after death of the transferor. Second, beneficiaries will likely not mortgage the property for several years as well. Third, the transferor has clear ownership of title to the property with no clouds on the title. Fourth, there will likely be no creditors or other significant debts on the transferor's death that would potentially lead to any creditor claims during those 2 years after the transferor's death. And the real property is owned outright without a mortgage. Fifth, the transfer aligns with the transferor's estate plan and wishes and contemplates the designated beneficiaries potentially predeceasing the transferor. Last, the designated beneficiaries are made aware of the transfer on death deed, as well as the affirmative steps that they will need to take after the transferor's death. Now, in closing, I hope to have given you all some food for thought, especially if you were contemplating transferring Washington real property outside of probate. Please be aware there are significantly more intricacies and considerations than I could cover in my short time with you today. And as each person's situation is unique, I recommend consulting with an estate planning attorney if you are contemplating implementing a transfer on death deed in your estate plan. With that, I thank you all for your time and attention, and would like to transition the webinar back to Mike to begin the question and answer session. Mike?
Meng, thank you so much for that great presentation on transfer on death deeds and all the related issues. We do have a few questions. One is, what's a compelling reason to use a transfer on death deed, or under what circumstances? I think you touched on that, Meng, but if you want to elaborate on that, and is it better to transfer real estate via a will or a revocable trust?
So I did touch on the compelling reasons, and I do think that, so I usually recommend that everyone has a will, just to make sure that their wishes are not frustrated, as attorney Joshua Reinertson touched upon previously. But transfer on death deed can be used, especially with modest estates, to make sure that you don't have to go through probate, especially if there's only a few number of assets there. But in regards to will or revocable living trust, I do typically recommend at a minimum having a will. Having a revocable living trust is great if you would like to have a little bit more privacy with how you would like your estate distributed, as a will is filed with the court. So everyone does get to see in the court record exactly what distributions are being made versus living trust, where those terms can be restricted. However, bearing in mind, any deed that's filed is in the public record. So people can sit there and research and find out what transfers are being made from who to whom.
Okay, thank you. A question, Josh, that came in to me directly was on the transfer of assets from a parent to a child when the parent is in a second marriage or a CIR. Does the surviving spouse or partner have a claim to that? That's kind of a complicated situation, but do you want to address that, please?
Yeah, so I think if I'm understanding the question correctly, that really goes back to, can one spouse, what do they have authority to dispose of, right? And it's really, the Washington statute says, under your will, you can dispose of all of your separate property and half of your community property, however you want. It doesn't have to go to the surviving spouse. Gifting is a little bit different. If it's separate property, you can gift that without anybody's consent. If it's community property, you can't gift without the express or implied consent of the other spouse, and that's just because it shrinks the community property, right, and thereby shrinks the other spouse's interest. So it's really kind of a question of defining what is actually community and separate, which can be a little bit murky, and that goes back to defining that in an agreement, a prenuptial agreement or postnuptial agreement, or we sometimes call a property status agreement too. So hopefully that answers your question.
Okay. Anton, Meng, Carla, do you want to also comment on that?
I think Josh handled that one comprehensively, but Anton, if you have anything to add.
No, I'll leave that with Josh. That was great.
All right. So Anton, on the powers of attorney for the young adults, what's the best way for a parent to introduce that idea to their young adult? Any tips, practice tips on that direction?
Yeah, a few different options. If you've got an agreeable young adult, simply just bringing it up and suggesting that they get a power of attorney, and even maybe helping them schedule a meeting with an attorney, since they may not want to put that on their schedule. If you've got a more disagreeable adult and you really want to make sure, young adult, but you want to make sure they do it, and let's say you're paying for tuition for college, you could give them a little bit of a nudge and say, we're paying for your tuition. If you want to make sure we keep doing that, you should probably do this. So there's different levels of pressure you can put on a young adult too, depending on their level of aversion to it, to make sure they get it done.
Okay. And then Carla, on the planning for the young beneficiaries, you touched on the guardianship conservatorship, but could you just again kind of review that with us, to what's the distinction between a guardianship and a conservatorship?
Sure. So a guardianship for a minor is a court proceeding in which the court appoints a guardian to manage the minor's medical, educational, residential, all of those sort of person-oriented decisions on behalf of the minor. And a conservatorship is where the court, through a court proceeding, appoints a conservator to handle funds that the minor is receiving or is entitled to receive through some type of settlement, including a probate distribution. So the reason why conservatorships can come into place without appropriate planning is that a minor, as I mentioned, cannot receive funds or assets in their own name. So if planning protections haven't been put in place in your documents, then the court will need to appoint someone who can hold and manage those assets on behalf of the minor. And although all of us here are very friendly with the courts and are grateful to the courts, any court proceeding like a conservatorship or a court established and monitored trust is invasive and costly. So to be avoided if possible.
So I know folks are always concerned about legal fees. So I think, to your point, one of the best ways to be proactive in planning and reduce legal fees is to actually do the planning, so that the documents are in place and the protections are in place. And we're not really addressing special needs trust, but for our audience today, I do want to point out that for minors or young adults receiving any public benefits, the planning around that is really critical to ensure that they retain those benefits as they become young adults. And we refer to them as special needs trust, but there's different types of trust planning around that that Carla, Meng, Josh, and Anton are all familiar with and are available to work with clients and families in making sure that those trusts to maintain and secure public benefits are in place. And it looks like we don't really have any other questions. So again, we want to thank our presenters and want to thank those attending today. This webinar will be posted on the website as our prior webinars, and you're invited, welcome, encouraged to go to the website, read the attorney profiles, become familiar with some of the news blogs, and then the various other webinars that we've given over the past several months. So with that, I'll sign off. And again, thank you and look forward to seeing you all again. And please don't hesitate to reach out to Carla or Anton, Josh, and Meng and me with any questions. And we appreciate you being here. Thank you.
Thank you.
Thanks.
Bye.
Bye-bye.
you.